we've had our election, and Donald Trump is the president-elect of the United States. One of the issues that going into the election that got a lot of conversation and discussion was the U.S. Supreme Court. We know that there is one vacant position due to the death of Justice Antonin Scalia, and the new president will not only replace that person, that seat, but may, as you will hear the professor say, may actually appoint an additional 1 or 2 people to the court, obviously depending on how things go. We have some members of the court who are getting up in years, so we will see about that. So what does it all mean, the election of Donald Trump, when it comes to the U.S. Supreme Court? For that, we're going to turn to an expert in the field. He has a biography that is literally reams long here, but to give you the Reader's Digest version, Professor Wallace teaches it at Campbell Law, right across the way from us. He teaches constitutional law with a concentration in free speech, church and state, right to arms, and constitutional interpretation. His doctoral dissertation, it sounds really fascinating, it's called Higher Call, Foundations of Religious Freedom in American Constitutionalism. Now, before joining the faculty at Campbell, he was a visiting professor at the University of Arkansas Little Rock School of Law. He also served as a law clerk to U.S. District Judge Susan Weber Wright. So to find out what it all means, what we can expect over the next few months, please welcome Professor Greg Wallace. I'm going to ask you to put that on your lapel. If you want to walk around.
Okay, good. Yes.
One final thing. One thing I also wanted to ask, I know there's going to be lots of questions that people will have. What we'd like to do is let the professor make his presentation and then take questions at the end, because we know there's going to be a lot of them. We'll try to get to as many of them as we can.
Donna, you want that? Okay. Thank you, Donna, for that very kind introduction, and for the invitation to speak here. I appreciate so much the work of the John Locke Foundation. Yesterday afternoon, I was out at the Umstead Hotel with a bunch of, at a convention for state intermediate appellate court judges, and was speaking on a panel out there on the subject matter for today, the Supreme Court, future of the Supreme Court after the election. And I was there with a Duke law professor and a Carolina law professor, and Dahlia Lithwick, who is the Supreme Court reporter for Slate magazine. And it was 3-1. So my first comment after we went down the panel for the first range of comments, my first thing I said was, I dissent, and which was immediately understood by all of the judges there. But today I'm in a little bit more friendly environs, and I'm grateful for that. Of course, the elephant in the room with the Trump election was the seat vacated by Justice Scalia upon his untimely passing. And I want to say just a couple of things about Justice Scalia. With his brilliance and wit, he single-handedly transformed the terms of debate about the Constitution and the rule of law. I think he helped move the Supreme Court from a somewhat sloppy, results-oriented, center-left institution to a much more intellectually rigorous, center-right court that emphasized text and history over other modes of constitutional interpretation. I think his most significant contribution, of course, was his powerful defense of and use of originalism in constitutional interpretation. When he was first appointed to the court, most justices and legal scholars tended to ignore the original meaning of the Constitution and instead treated it as if it were a living document or a sort of empty glass, which the meaning of which changed over time to fit current cultural values and political concerns. Scalia reminded, he admonished, he even scolded at times his colleagues and the entire legal community that modern law is all about legal text. The text of statutes, the text of agency regulations, and the text of Constitution itself. In his view, the role of judges is to interpret the text according to its ordinary meaning, read in context of the whole document or statute as well as precedent and tradition. And I think perhaps the greatest sign of Scalia's influence is that liberal justices and scholars now make arguments about constitutional text and history. There's even some more liberal law professors who claim we're all originalists now. Well, I don't I don't think they mean what they mean by originalism is what Justice Scalia would mean by originalism, but at least it's certainly a bow in his direction in that grade. I think his greatest opinion was the one that I teach that's really at the heart of a course that I teach on firearms law and the Second Amendment. Yes, we do offer that course. And that's the Heller decision about the meaning of the Second Amendment, where he engages in a robust debate with Justice Stevens, who, if you've read anything that Justice Stevens has written, you know that he was about as far from an originalist as can be. And yet they debate about the original meaning of the Second Amendment, turning Justice Stevens, at least for that opinion, into an originalist. Now, let me just make one comment or a comment or two about originalism. This came up in the panel yesterday, and one of the panelists said, well, originalism is still results-oriented, and it's really no different than what the liberal justices do. And I said, well, I beg to disagree with that. I think originalism, there are three things that I tell my students about originalism. First of all, originalism requires that we treat the Constitution as legal text, not as some sort of living document or some unusual type of legal entity here that whose meaning changes and grows, kind of like a living thing. The Constitution is simply legal text. We deal, as lawyers, we deal with legal text all the time. The text of contracts, the text of property deeds, the text of statutes, regulations, these kinds of things. And the Constitution is no different. Now, because the Constitution is legal text, we should interpret the Constitution like we do other legal texts, like contracts and property deeds, etc. In that we should give the language of the Constitution its ordinary meaning as it was understood when that language was created. The ordinary meaning that reflects not the original intent, but the original public understanding of the meaning of that text when the constitutional text was ratified. In fact, as I tell my students, the only authoritative meaning of the Constitution is the meaning that was ratified by a supermajority of persons when they voted to add that particular text at the time to the Constitution. So the meaning of the Constitution is what a supermajority of American citizens ratified, not what I think it means or what you think it means or what 5 lawyers in Washington think it means. It's the only official meaning of the text is the ratified meaning. Now, I would agree with the professor who made the comment yesterday about that any system of constitutional interpretation, whether it be living constitutionalism or originalism, any of those interpretive methods can be used to produce certain results. That's true, and originalism is not foolproof in the sense that it always guarantees that the text will be interpreted properly and fairly consistent with history and the text itself. It's not an infallible approach. But I tell my students that I believe that it is the best approach to constrain judges from smuggling in their own political preferences into the law under the guise of constitutional interpretation. originalist judges and justices at least have to explain, in their opinion, why the result they are reaching is consistent with the original public meaning of the constitutional text. So while it's not infallible or foolproof, I think originalism, as Justice Scalia espoused it, is the best way to keep us from having just unrestrained judicial lawmaking like we have seen in, particularly in the area of substantive due process over the last, 25, 35 years, probably beginning with the privacy cases in Griswold and Roe and coming forward to the Obergefell case just the last term. Now, let's talk about the election and what it represents. Supreme Court appointments were a big issue in the campaign. 21% of the voters, which is 3 times more than 2008, said that appointments to the Supreme Court were the most important factor about which presidential candidate to support. Voters who said the Supreme Court was the most important factor preferred Trump over Clinton 57% to 40%. So now I know many people who voted for Trump mainly on the Supreme Court issue. I think, and I think this is something that the progressives and the liberal media are having a hard time accepting. I told somebody before the election that I said that that one of the things, if Trump wins, and I really thought he might would win. And I said, if he does, the thing that I'm going to probably enjoy the most is seeing the meltdown among progressives and how to handle this, how to handle the outcome there. But I think that the whole question of Supreme Court appointments was a significant driver in the vote that put Trump in office. I think the perception that progressive policies have been forced on American citizens contrary to perceived constitutional procedures was a strong motivating factor in people preferring Donald Trump over Hillary Clinton. Now, I don't think the vote was necessarily about the Obergefell decision, but I think it was part of a growing pattern, as I said a moment ago, that began with Roe versus Wade. Same-sex marriage might in fact have succeeded. In fact, in many places it was, through a fair political process decided in state legislatures. But that's quite different from a court imposing that and changing a fundamental social structure in a way that many people thought was illegitimate. And if any of you have happened to try to muddle through the Kennedy opinion in the Obergefell case, you will likely emerge from it like my students do, scratching their heads and saying, what does this mean? This notion of some constitutional right to dignity or respect or whatever. Wow, that's so open-ended. And the approach that Justice Kennedy and the majority used in that case is typical of modern substantive due process. It is just simply open-ended without any meaningful constraints on it. And as I said, that's where judges and justices are smuggling in their own political preferences under the guise of constitutional decision-making. And I think this election was something of a referendum on that kind of constitutional approach. At my panel yesterday, one panelist accused Mr. Trump of disparaging the rule of law. And when it got to me, I said, well, let's consider what kind of justices Hillary Clinton would have appointed. When asked in the third debate what kind of justice would she nominate, Mrs. Clinton never mentioned the Constitution, but instead said that she would nominate someone who would oppose powerful corporations and the wealthy and stand up for women's rights and the rights of the LGBT community. She confused apparently confused judges with legislators when she promised to appoint a court that represents all of us. Well, of course, by us, Ms. Clinton does not mean supporters of traditional marriage, gun owners, pro-lifers, or her political opponents over at Citizens United. For Clinton, the ideal justice is one who decides cases based on the litigant's identity or status, not on what the constitutional or statutory text requires. Her appointees, frankly, would have been hard-pressed to honestly take the oath for Supreme Court justices by which they swear to, quote, administer justice without respect to persons, unquote, and to, quote, do equal right to the poor and the rich, unquote. The rule of law requires that the little guy wins when the law favors him, while big corporations win when the law favors them. Now, given Clinton's promise to appoint justices who protect her favored groups rather than to uphold the rule of law, I think it's hard-pressed for anybody to disparage Mr. Trump as not adhering to the rule of law. In fact, had Mrs. Clinton been elected, I would have supported a decision by Senate Republicans to have refused to confirm any nominee that she sent over for however long she was in office, based on the criteria that she set forth in her comment at the third debate. Now, on President-elect Donald Trump's website, there's a statement that he has on judicial appointments and constitutional rights. One of the things he says is that he is going to nominate judges and Supreme Court justices who are committed to interpreting the Constitution and laws according to their original public meaning. It says also that he will defend Americans' fundamental rights to free speech, to religious liberty, to keeping and bearing arms, and to all other rights guaranteed to them in the Bill of Rights and other constitutional provisions. He goes on to say that this includes the 10th Amendment guarantee that many areas of governance are left to the people in the states and are not the role of the federal government to fulfill. Well, I think it's interesting here that President-elect Trump officially embraces the original public meaning as the proper interpretive approach to the text of the Constitution. He stands with Justice Scalia in that regard. It's also nice to see that he mentions the 10th Amendment as one of the rights of the people. It's nice to see that we have a president who doesn't think necessarily that the federal government should be about governing every single issue in the lives of Americans. I think it's also rather telling that he embraces the rights guaranteed by the Bill of Rights and other constitutional provisions. I think this seems to exclude non-textual rights, such as the right to privacy or the right to abortion or even the right to dignity that would allow same-sex couples to marry. And finally, unlike Secretary Clinton, who in her concession speech spoke of the right to worship, which is an exceedingly narrow view of the religion clause, Trump speaks of religious liberty, the right to share and live out our beliefs and to participate in the public square. I think that if he remains consistent to that, I think we're going to see a tremendous effect in regulatory policy that broader view of religious freedom will bring. Are these mere words? Well, we'll see. I do think that the prediction that originalism will recede after with the passing of Justice Scalia, I think the reports of originalism's death are premature. In fact, we may see our first set of new justices who know what it is and how to use it as an interpretive guide. Now, when I said these things about President-elect Trump yesterday, one of the panelists accused me of the normalization of Donald Trump. That's what his phrase was. I told him I thought that was a cute phrase, and wish I thought of it, but I said no. I said any normalization of Donald Trump will come through Trump's actions going forward. My point was that while Trump's opponents can certainly point to things that he said as cause for concern, I can point to other things that he said that places him in the mainstream of conservative legal thought, especially when it comes to constitutional rights and Supreme Court justices. But again, we will have to wait and see. Let's hope these are not just mere words. Another panelist was concerned about Trump's possible abuse of executive power. And I would say that that's a concern that we have with anybody that's elected president, because the way it usually rolls is that as a candidate, the person will criticize executive overreach, but when the candidate then becomes president, the candidate will do everything he can to engage in executive overreach. I think we've seen that clearly in a number of instances in the Obama administration, where he's said he's going to use his pen and his phone when Congress doesn't do what he wants them to do. And we've seen all sorts of examples of executive overreach in the immigration area, in Obamacare, and even in the interpretation of Title IX, which prohibits sex discrimination in education. Now, I said yesterday that I think Donald Trump will be the most checked and balanced president in modern history. You've got a media that's going to immediately be hostile to him. It's been hostile to him throughout the campaign. They're going to scrutinize every single thing that he does. You've got Republicans, many Republicans in Congress that didn't support him in the election. And they're not going to just roll over and do whatever he wants them to do. They're going to push back as well. And then I think you're also going to have judges and justices in the courts that are going to also check him. I think it's interesting to me that I think adherence to an originalist interpretation of the Constitution, as he has said he will appoint justices reflecting that or embracing that, and the comments that he made about the 10th Amendment on his website, I don't think you can get unlimited executive power out of the set of historical materials supporting an original Federalist understanding of the Constitution. And I think that one of the reasons why the court has been more solicitous of the advance or the reach of executive power has been its abandonment of federalism. And so I think the notion that the federal government is not the ultimate all-powerful government that has to do anything and everything that affects the lives of Americans, and that there are some things that are properly left to the states and to the people, is something that is not going to certainly be consistent with broad executive overreach. But again, I think the point is we will have to see. Now, as far as the vacancy goes, we have since Republicans retained control of both the House and the Senate, I will presume that both Trump and the Senate are going to move quickly to nominate and confirm a replacement to fill Justice Scalia's seat. There also, this is something that a lot of people don't realize, there are also 103 current vacancies on the federal bench, 22 of them at the appellate level. So, as I understand, so they will be active as well in filling these lower courts. And let me tell you something: we should not underestimate the importance of the appointments both to the district court and especially to the circuit court. We've seen that during the 8 years of President Obama being in office, because of his appointments to the Fourth Circuit, that the Fourth Circuit has transformed from being the most conservative circuit in the nation to being one of the most liberal. And so the fact that President Trump will be appointing lower federal court judges as well is significant. Now, who is he going to appoint to fill Scalia's seat? I assume it's going to be from one of the judges from the two lists that he released to the media prior to the election. There's I don't know that there's anybody on. I've looked at all of the names on the list, looked at their backgrounds. I don't know that there's anybody here with the brilliance and wit of a Justice Scalia. He was one of a kind. But all of these judges apparently share his approach to constitutional decision-making in that they emphasize the reading of the Constitution as legal text and relying on the original public meaning of that text. Trump's list has been vetted, as I understand, by members of the Federalist Society and the Heritage Foundation, which they stand in certainly the mainstream of conservative legal thought here. So I don't think we will see, as long as he sticks to those lists, I think we'll see a very solid appointment to the Supreme Court. What is interesting to me is that I presume that the Senate Republicans will abandon the filibuster should the Democrats try to block consideration of Trump's Supreme Court nominee. They certainly will have political cover for doing so, given the Democrats' abandonment of the filibuster with respect to the appointments of lower court judges when they were in control of the Senate, with Harry Reid was the majority leader, and the open discussion that Democrats had prior to the election. For example, Harry Reid was talking about this, Tim Kaine was talking about this, of doing just that, of abandoning the filibuster, had Clinton won the presidency and the Democrats had had captured the Senate. So the Democrats were signaling that they were planning on doing that very thing, and I think that the Republicans ought to do it. I've never been a big fan of the filibuster. There's no problem in terms of constitutional principle with abandoning the 60-vote threshold. In my view, it's actually anti-democratic and undermines the democratic functioning of both houses of Congress, which the Constitution specifically sets up as and this supermajority requirement of the Senate, I think, is in my view, now a lot of people don't share that, but I think borders on being unconstitutional. What would be interesting is to see, what's going to happen to the nomination process once if the Republicans do in fact abandon the filibuster. Are we going to see more open discussion of constitutional doctrine during the hearings on that nominee when the nominee needs no more than a majority? Does that kind of a scenario free President Trump from to nominate somebody with a clear track record? In other words, no more David Souters in that regard. I think it'll be interesting to see the effect of that if the Republicans do abandon the filibuster for Supreme Court nominees. Now, as far as where the court's going in the future, the Supreme Court usually hears about 70 cases from nearly 7,000 petitions that it reviews. So far this term, which started in October the 1st, the court has agreed to review 51 cases so far, and it's set 27 of those for oral argument. I think we can certainly say that the Garland nomination is dead. The Senate Republican strategy of not holding hearings or voting on Obama's nomination there worked, and it certainly didn't seem to hurt Republican senators running for re-election. I was somewhat amazed by the lack of understanding of the appointment process and the large number of law professors and so-called constitutional experts who were arguing that the Constitution requires the Senate to give an up or down vote on the Garland nomination. No, the Constitution commits the nomination of a Supreme Court justice is too important to just leave that to one branch. The Constitution commits it to both the President who nominates and the Senate, who confirms or does not confirm. There are no legal standards for how that process is to move ahead in the text of the Constitution, which means that it's all up to the political process. If the Republicans, wanted to hold out, then that was a political calculation that they had to make. Would that hurt them in terms of the next election? And apparently it did not. So the political calculation was good there, and the Senate Republicans made the right decision in that. I think another effect of the Trump election is Justice Kennedy is probably almost certainly going to continue to be, at least in the short term, the swing justice on the Supreme Court. Really, in some ways, he's the big winner from this election. The court docket will likely shrink. There are many high-profile cases that are looming on the Supreme Court that will simply go away because of a change in executive policy. You live by the executive pen, you die by the executive pen as well. In the immigration area, the case challenging Obama's DAPA, the Deferred Action for Parents of Americans program, which the Fifth Circuit held that Obama had exceeded his executive authority, and then by a 4-4 vote last term, if you recall, in a single sentence, it said that the Supreme Court upheld the decision of the lower court, by an equally divided court, which did not was not precedential in the sense that it did not, it simply affirmed the Fifth Circuit. It did not set any precedent going ahead. That case will go away, essentially because President Trump will change that policy. Also, wending its way through the courts is a challenge to the DACA, the Deferred Action for Childhood Arrivals. That case likely will go away as well. In the area of religious freedom, last May, the justices were unable to resolve the appeal of the Little Sisters of the Poor and other religious charities who objected to Obamacare's contraceptive mandate. Obama insisted that the female employees of the charities be provided contraceptive coverage under the same plan that covered their regular doctor visits. The charities wanted contraceptive coverage to be provided under a separate plan. The Supreme Court told them to go back to the negotiating table and get this resolved, which I think was a win for Little Sisters of the Poor, because under the Religious Freedom Restoration Act, if there is any less restrictive means of achieving the government's purpose, then the government loses. And I think by remanding the case back for further negotiations, the court implicitly recognized that there was a less restrictive way, a way that was less restrictive of the Little Sisters of the Poor's religious freedom to address the contraceptive issue. That policy will probably change under a Trump administration, and that case will go away. In the environment area, the Clean Power Plan likely will be rescinded, and the EPA would then commence rulemaking process to rescind the Obama administration's, he did campaign, but the Obama administration's interpretation of the Clean Air Act. I think the Trump administration then would ask the D.C. Circuit Court of Appeals to put on hold the pending litigation there over the Clean Power Plan. With Obamacare, Trump's Department of Health and Human Services will almost surely stop making illegal payments to insurance companies, and so that will end the lawsuit brought by the House of Representatives against the Obama administration, which was challenging the payment of those subsidies. Even with transgender rights, the case from Virginia that the Supreme Court granted cert on, the Gloucester School District versus GG, where the Fourth Circuit said that the school district must follow the policy, not a rule, but the policy that was made by the Obama administration interpreting Title IX to guarantee the rights of a transgender students to use the restroom, shower, or changing facility of their choice. The Supreme Court granted cert on that. I would think, again, the Obama administration is going to change that interpretation of Title IX. Since Congress has had ample time to amend Title IX to add sexual orientation and transgender or gender equality to the language of Title IX and has not done so, the attempt by the Obama administration to bootstrap those protections into the protection, the prohibition against sex discrimination, I think should come to an end in the Trump administration. That case will likely go away, as will some of the cases that are winding their way through the lower courts challenging the Dear Colleague letters in enforcement of the sexual assault provisions of Title IX that has deprived a number of persons on college campuses of due process rights. So I think a lot of cases are going to go away. As I said, you live by the administrative sword, you die by it as well, by simply a change in policy under the Trump administration. There are some interesting cases that are still pending before the Supreme Court. One religious freedom case out of Missouri that itself may go away because the new Attorney General now that's been elected of Missouri actually, I think, is a former law professor and worked with the Alliance Defending Freedom and probably will make that case go away. There are a couple of cases from North Carolina, the Packingham case, which challenges North Carolina's law that makes it a felony for any person on the state's registry of sex offenders to access a wide variety of websites. That's going to be an interesting case. The Court of Appeals in North Carolina struck down the laws applied to Mr. Packingham. The Supreme Court of North Carolina reversed that case and said that the access was conduct, was not speech, and in any event Mr. Packingham had ample alternative channels by which to engage in those expressive activities. I think this is a case where the Supreme Court could clarify the ample alternative channel aspect of First Amendment doctrine. There's a very interesting case called the Slants Case. Simon Tam, who was an Asian American musician and political activist, formed a rock band to play music and to be a vehicle for expressing Mr. Tam's views on discrimination against Asian Americans. He recruited Asian American band members and called the band the Slants. He naming them followed a long tradition of what's called reappropriation, where groups reclaim terms that were once derogatory and now use them as an expression of pride. When he tried to register that name as a trademark, he was denied under the disparagement provision of the Lanham Act, and which says that trademark registration shall be refused if the trademark consists of a matter which may disparage persons living or dead, institutions, beliefs, national symbols, or bring them into contempt or disrepute. The challenge to the provision here is being contrary to the free speech clause of the First Amendment and unconstitutionally vague. I think Mr. Tam has a case here. This law discriminates on the basis of viewpoint, and the government's justification for the law is, well, we have to do this to prevent somebody from being offended. That's never been a sufficient justification in First Amendment law before for restricting people's speech. So I think I'll stop there and open it up for questions. Yes?
Specific to Title IX and our wonderful HB2 and all of the misinformation that is out there, as a respected legal scholar, could you point to gentleman behind you, respected in some circles, how about that? Could you point to the codification of within the transgender community, the definition of gender fluidity? Could you point to a codification either legally or medically as to a definition that could be placed into public policy that could withstand court scrutiny?
No, I can't. And I think that what's very interesting about the Obama administration policy here is now note, the Obama administration says sex discrimination includes protections for discrimination against gender identity, based on gender identity. And they claim to be interpreting a regulation that created an exception to the general prohibition on sex discrimination under Title IX for the separation of sexes in bathrooms, showers, and other changing facilities. Now they say we're interpreting that regulation, so that's how they get to a form of deference under a Supreme Court doctrine that's too complicated to go in here today. But I think it's really disingenuous for them to say we're basing our interpretation on a regulation that was created to protect privacy, okay, so that the prohibition on sex discrimination would not do away with bathrooms and showers and changing facilities, male and female. In fact, Justice Ginsburg, while she was still a law professor, wrote an op-ed piece back in 1975 when the ERA was pending, and people were saying that, well, that's going to eliminate, it's going to eliminate gender distinctions in bathrooms. You know, everybody's going to have to go to the same bathroom. And Justice Ginsburg wrote an op-ed and said, no, that's not, because there are some places where privacy trumps equality. Well, it's disingenuous to me for the Obama administration to use a regulation that was created for the purpose of protecting privacy between male and female and say that that regulation requires a person with male genitals to be able to give that person a legal right to go into a locker room that is populated with females and undress and shower in front of them. That is just astonishing to me that the Obama administration could come up with something like that. It's crazy. It is unjustifiable. And look, if Congress wants to add that, wants to do that, go through the legislative process, or if the administration wants to do that, go through the rulemaking process. But simply to do that on the basis of a letter from the Justice Department, and it raises all sorts of inconsistencies and problems under Title IX that ultimately would lead to the doing away, really, of separate bathrooms for men and women, and probably separate sports for men and women as well. So yeah, that's just crazy. And the Fourth Circuit was crazy to uphold it.
If I may follow up, in your legal opinion, is there any way to, and again, I reference within the LGBT community, there's essentially 31 genders identified. Right. One of them being gender fluidity. Is there any way, in your legal opinion, by which a policy, legally or medically, can be codified to accommodate that specific component gender?
Well, I think the only way to do that is to just do away with distinctions between male and female altogether in the law. I think that's where we're headed. And listen, I think there are some people who want that. Yes, sir.
The thing that got me about this whole thing is how the lack of an accommodation is called discrimination. And that's what it is. You can't get everything you want because you say so. You're not going to be accommodated. And all of a sudden they become a discriminatory issue. And I don't think it is.
Well, the House Bill 2 does provide that government agencies can accommodate transgender persons by creating unisex bathrooms or whatever, but the claim that they make, on the other hand, is that stigmatizes them. I don't know. I mean, we have unisex bathrooms in our law school in addition to male and female bathrooms, and some of my colleagues prefer to use the unisex bathroom just because that accommodates their privacy interests best. I don't think that's anything that outs them as anything, other than just somebody who would prefer to use a unisex bathroom. But anyway, I don't want to get too far afield into House Bill 2 here. Yes?
You say the original meaning of the Constitution as it was then thought to.
Yes. Mm-hmm.
That's probably a pretty difficult thing to define.
Sometimes it is. And again, the original originalist constitutional interpretation is not a perfect constitutional method. It has its limitations. Sometimes the history is just not there to be able to make a determination, and then the interpreter has to decide, well, if we cannot understand what this meant originally, then is this we go to a default rule, and is the default rule simply then just deference to the legislature? If we can't say the Constitution prohibits it because we understand the meaning of that, then that was Scalia's view, that you just default to a deference to the legislature. Other people would say that you default to a rule that maximizes freedom because the Constitution was really drafted not just to constitute our government, but also to limit the government's power over us as Americans so that we would be free. And so you default to the most freedom-enhancing interpretation there. But yeah, you're right. I mean, it's not, the original meaning is not clear in every instance.
Yes, one of the things that has concerned me from time to time is the rapid change of the world in which we live, and the fact that it seems to me to be quite some time since we've amended the Constitution. What with information revolutions and technology revolutions and wars with terrorism against non-nation states and so on, that we may not be keeping the document up to date, which will give those who do not want to have a literal interpretation of it more ammunition to say it's just an out-of-date document. I solicit your thoughts and comments on that.
Yeah, the framers of the Constitution understood it was not a perfect document. It certainly wasn't complete. Things would change going forward, and they provided a way to change the meaning of the Constitution through amendment. And the thing about amending the Constitution, it requires a supermajority of vote. It requires a lot of Americans to agree that this is a change that we need to make. You know, the court's substantive due process jurisprudence used to reflect that as well, in that the court would say, and I happen to believe, based on the Ninth Amendment, we don't have time to go into this, but I happen to believe that the Constitution does protect certain unenumerated rights based on the language of the Ninth Amendment. But the big question is, how do you identify what those unenumerated rights were? And what the court used to say is that these are rights that are deeply rooted in our nation's history and traditions and conscience. The problem is things like abortion or gay marriage are not things that are deeply rooted in our nation's history, tradition, and conscience. And so when the court starts identifying those and elevating them to the status of constitutional rights, those are rights about which the American public is very divided. And so I think the court is delegitimizing itself when it is siding with one half of Americans against the other half in identifying constitutional rights and circumventing this amendment process that really requires something, a supermajority of Americans to agree on before we change the meaning of the Constitution. Otherwise, everything's back to the political process. You know, the problem is we've constitutionalized too many things. Look, if you want gay marriage, and a lot of people favor gay marriage, make your arguments to the legislators, let the state pass it. And frankly, in both the case of abortion and in the case of gay marriage, the state legislatures were moving in that direction. They were liberalizing laws regarding abortion. They were accepting gay marriage. I've always said if I run for office one day, I'm going to hire the PR firm that represents the gay rights folks, because they have done a heck of a job in convincing the American public to respect gay rights and to accept gay marriage. But if you're going to do that in the legislature. This is not a constitutional issue. Do it in the legislature. Let that play out in the legislature. You might not have all 50 states agreeing on that, but that's the genius of federalism. But don't have it imposed by 5 lawyers in Washington through simply smuggling in their own views on this political issue under the guise of constitutional decision making. And I think that, and to wrap this up here, to come back to the first part, I think that is really what I think in many respects this election, at least in part, was a referendum on. That a majority of Americans are sick and tired of having these kinds of very important social issues that ought to be decided, in the legislatures, imposed upon them by the courts. Thank you very much.